What is or is not racist? This has recently become an issue with accusations of racial abuse and animus levelled against Sam Kerr, the captain of Australia's women's football team, who also happens to play for Chelsea. The accusations against Sam Kerr stem from a night out in the United Kingdom, in which Sam Kerr was reportedly out drinking. She then allegedly got into an argument with the taxi driver over a fare and also threw up. The commotion resulted in police approaching Sam Kerr, who then allegedly called one of the police officers, quote, a stupid white bastard. She was then charged with intentionally causing racially aggravated harassment, alarm, or distress toward that police officer. And this comes under Section 31(1)(b) of the Crime and Disorder Act, in addition to some other pieces of legislation. This occurred, like I've indicated, in the United Kingdom rather than in Australia. So the legislation underlying this is from the United Kingdom, and she has been charged with a criminal offence. Now, it's worth noting she denies the allegations and has pleaded not guilty. And of course, we need to give her the presumption of innocence. The facts will come out at court, and we shouldn't prejudge any ruling that might occur. However, this whole situation raises two questions. One, what exactly is racist? And then two, are laws like those in the United Kingdom justifiable? And I would be interested to hear your thoughts on this in the comments below. So let's start off with what the actual legislation is. What exactly is it that Sam Kerr has been charged with? Well, we should start off with Section 31(1)(b) of the Crime and Disorder Act. It states, a person is guilty of an offence under this section if they commit A, an offence under Section 4 of the Public Order Act, i.e. fear, provocation or violence, B, an offence under Section 4A of the Act, i.e. intentional harassment, alarm or distress, or C, an offence under Section 5 of the Act, i.e. harassment, alarm or distress, which is racially or religiously aggravated for the purposes of this section. So this begs two following on questions. One, when is something racially or religiously aggravated? And then two, what exactly are those offences under the Public Order Act? So to the first one, Section 28 of the Crime and Disorder Act states that an offence is racially or religiously aggravated for the purposes of those sections, so Section 31 in this case, if A, at the time of committing the offence, or immediately before or after doing so, the offender demonstrates toward the victim of the offence hostility based on the victim's membership or presumed membership of a racial or religious group. Or alternatively B, the offence is motivated wholly or partly by hostility towards members of a racial or religious group based on their membership of that group. Here, it would appear that it's being alleged that due to the nature of the language used, there is hostility evidenced at the time of the alleged offending. We then need to look at the Public Order Act, Sections 4 through to 5, to see what has been alleged about her conduct. Now, Section 4 isn't presently relevant here, because it involves actions that make the victim fear physical harm. That doesn't appear to be the case here. It doesn't appear to be alleged that the police officer feared physical harm in this situation. However, Sections 4A and 5 would become relevant. Under Section 4A, it says a person is guilty of an offence if they act with intent to cause a person harassment, alarm, or distress, and they are using threatening, abusive, or insulting words or behaviour or disorderly behaviour, or they display any writing, sign, or other visible representation that is threatening, abusive, or insulting. That is under Section 4A. Intention is important here. It's necessary to show that there was an intention to cause harassment, alarm, or distress. However, under Section 5, it merely states a person is guilty of an offence if they use threatening or abusive words or behaviour or disorderly behaviour, or display writing, a sign, or other visible representation that is threatening or abusive within the hearing or sight of a person likely to be caused harassment, alarm, or distress thereby. That is, Section 5 doesn't really have that intent element to it. It's just causing that harassment, alarm, or distress, and doing actions that are likely to cause that harassment, alarm, or distress. It's a very different and much easier one to satisfy, it appears. Now, like I have indicated, Sam Kerr denies wrongdoing, and she has pleaded not guilty. She is entitled to the presumption of innocence, and the true facts are going to come out at court. And we don't want to say anything too conclusive about Sam Kerr's conduct, because we don't necessarily have full details. It will go to the courts, and the judicial system will determine her guilt or otherwise. At present, all we have are the allegations reported in the media, We don't necessarily have the full context in terms of the footage of the incident or the tone that Sam Kerr was using. However, the police do reportedly have body cam footage of this incident, so therefore footage is likely to come out at court. Again, to be very clear here, I'm not prejudging her. What needs to be determined is what happens at court, and we're just analysing the law and whether the law is appropriate in this case. Now let's focus on the phrase "stupid white bastard," which she is alleged to have used. The question is, could that phrase plausibly demonstrate hostility and the like based on whether the person is white? Because it is going to be necessary to show that racial animus to bring this within part of the legislation. It's also going to be important to demonstrate that could cause harassment, alarm, or distress. So, to the idea of whether it could be racially abusive, it appears that it's likely that it could be. It doesn't appear to be that relevant necessarily that white people have been oppressors, or whether white people are privileged or dominant. That's not part of the law. The law doesn't say that it only applies to a particular group of individuals. Rather, it merely needs to be racially abusive to come within the law. Therefore, the mere fact, for example, that white people are alleged to be privileged or whatever, that isn't really going to help her situation if the facts are as alleged. The court will need to determine whether the offender demonstrates the requisite hostility on the basis of race, but it would appear using the phrase "stupid white bastard" would demonstrate this. Now, the legislation, like I've indicated, does not include or exclude specific races. Further, the courts have also held that hostility can exist even if the person is of that race themselves. So therefore, even if Sam Kerr is of the same background as the police officer, the racial animus and the abusiveness could still be alleged and could still be made out. Furthermore, even if there are other non-racial motivations for using such a phrase, that won't necessarily help, because it is simply sufficient that the phrase is racially abusive, even if there were other intentions to abuse on other characteristics as well, such as being stupid in this case. Now here, it would appear the phrase "stupid white bastard" could easily be construed as racially abusive. This is because, looking at that phrase, if you were to substitute out any other racial group, whether it's a person from Asia or whether it's a person who is black or whether it's a person from any other background, that would likely be deemed to be racially abusive. Therefore, when the court is looking at what precedent it's going to set, it needs to consider, well, if we say that "stupid white bastard" is not racially abusive, then what are we saying about other phraseology? It would appear that you need to have a consistent rule, and in the law you need consistency. And if they're going to say that the phrase "stupid white bastard" is not racially abusive, but it would be racially abusive to substitute in another racial group, they're going to need to have a very strong justification for that, because otherwise it's going to set a very weird effect. Furthermore, as a matter of statutory interpretation, it's generally assumed that the legislators did not assume an absurd result. It would be an absurd result to change the impact of the law based on the racial group in which the person is from, because laws are supposed to affect all people equally. They're not supposed to apply just to one group and not to another. Laws are supposed to protect all people in the same manner. Another issue is intention, whether it was intended to cause harassment, alarm, or distress. Now, as far as I can tell, Sam Kerr disputes intending to cause any harm or distress, and that will be determined at court. The body cam footage from the police officers will give some insight into this. Now, while intent might sound subjective, we would normally make inferences about this from how the person behaved, i.e. what happened before, after, and during all of this event, in order to determine what their intention was. It's not also going to be good enough for someone to say, "I did or did not intend a particular thing." You are going to infer that from how they acted, which would possibly come out through the body cam footage. Additionally, even if Sam Kerr did not intend to cause harassment, then it would still have issues with Section 5. It's going to be important for her to defend against that, because it appears under Section 5, well, it's sufficient for the phraseology to be likely to cause distress or alarm or harassment, and therefore she's going to have to argue that the phrase would not be likely to cause distress, harm, or harassment if it is in fact the case that she said that phrase. Now, the answer would seem to depend a little bit on whom you ask in the public sector. However, that's not really going to be what really comes into play. For example, New South Wales Premier Christopher Minns has suggested it would not be distressing. not distressing to him anyway. But he is not the judge. There is certainly an arguable case that calling someone a stupid bastard could be distressing, or at least alarming, maybe. It depends on exactly the situation. Furthermore, it could be even more so when you couple it with a racial term. That might be distressing to people. Now, in this particular case, the individual was a white police officer. However, like I've indicated before, if you substitute in any other racial group, then it would likely be distressing to that individual. At least that's what we have been led to believe from a lot of the media reporting. And therefore, the court is going to need to put up a consistent rule in relation to this type of thing. And this means there's at least an arguable case that the phrase might fall within Section 5 of the Act. Courts will consider the type of precedent that they would set, and therefore they need their rules and their determination to apply equally across individuals. And it's unlikely that they'd find that one racial group could be alarmed or harassed or distressed, but another racial group might not by similar phraseology. But again, that will come out at court. I should also note that this phraseology might also be regarded as distressing in this context specifically because it was a police officer seemingly inquiring as to what Sam Kerr was doing. But some people might infer that maybe she was alleging the police officer was himself racially biased, i.e. the use of the phrase stupid white bastard might be implying he is acting against her due to racial animus. And that would be a rather serious allegation to be leveling against a police officer. And that itself, that implication with the racially loaded phraseology, might also cause distress given the totality of the statement given out. And therefore it could also fall within Section 5 potentially. But again, a lot of this is going to determine on the full set of facts that ultimately come out. And as indicated, Sam Kerr denies the allegations and she has pleaded not guilty. And she is entitled to the presumption of innocence. And none of us have all facts to be able to judge this case. Now, as for whether laws like this should be on the books, well, you can let me know your thoughts in the comments below. To my mind, I think they should be very, very narrowly construed. I think the UK law is too wide. I think criminalizing language that might cause alarm or distress goes rather too far. There needs to be more tight limits on this. It's simply far too broad. Distress can involve a lot of things, and simply being likely to cause distress is seemingly a very low bar. But again, let me know your thoughts as well. And otherwise, hopefully this video has been interesting and useful to you. It'd be great if you liked the video and subscribe to the channel. And hopefully I see you next time as well.